A very warm good evening to everybody. Welcome to Clap Possible. We are here today to discuss this new Bharatiya Nagarik Suraksha Sanhita bill. ठीक है, तो आज का हमारा टॉपिक रहेगा जो नया नवेला हमारा क्रिमिनल लॉ के one of the three bills, which are going to be targeting at changing the entire criminal law, the way we've been studying criminal law, the way the law it's been governed. So there is a big change which is being brought about by these three bills, right? So in the last session that I had with you, we had actually picked up on one of these three, right? If you remember, that was the Bharatiya Saksh bill. That was basically the Indian Evidence Act, right? The Indian Evidence Act में क्या-क्या major changes हो रहे हैं with this bill, apart from the name, of course, name तो बदला ही है, उसके साथ-साथ additionally what all changes have been there, right? So today on the same lines, we are going to be talking about the Bharatiya Nagarik Suraksha Sanhita, which is basically what we are talking of, the changed name of the criminal procedure code, right? Or code of criminal procedure. So here we are again talking of the procedural law so far as criminal justice system is concerned, right? So broadly, like I was saying, that these three are the new bills. I'm sure all of you are aware of these three bills being introduced by the Union Minister, Home Minister, and he is the one who had introduced it on the 11th of August. And now the bills are with the Parliamentary Standing Committee on Home Affairs, wherein they are being examined by this particular committee, right? So abhi ye sirf bill hai, inka law nahi bana hai, right? So I get a lot of questions from students ki ma'am ab to naya law aa gaya hai, so do we need to study IPC, do we need to study CRPC, do we need to study Indian Evidence Act? Yes boss, abhi law yahi hai. Law hasn't changed, right? This law is still the same. These are still in the form of bills, right? So till the time they are not passed by the Lok Sabha, the Rajya Sabha, they don't get the presidential assent, they are not going to be the law of the land, right? So law governing criminal justice system is still what is given under your CRPC, CPC and IPC. ठीक है, तो हम आज जो है specifically we are talking about Bharatiya Nagarik Suraksha Sanhita bill. That means we are looking at the criminal procedure code. ठीक, तो अब always remember, whenever you look at the criminal laws, these basic three criminal laws, this here, your Bharatiya Nyaya Sanhita is basically your IPC, is your procedural law. This is your substantive law, right? So this is your substantive law, a law which is giving you rights and liabilities. बता रहा है कि क्या आपका right है कि भी अगर कोई चोरी हुई है, theft हुई है आपके घर में. So yes, that means you have a right over your movable property. Nobody can steal, take your movable property away from you without permission. So IPC हमारा substantive law है जो हमें देता है rights. On the other hand, जब हम CRPC पे आते हैं, which is your Bharatiya Nagarik Suraksha Sanhita bill, which is the new avatar as they call it. So जो नया अवतार है इसका, this is in the form of instead of CRPC, this is the new form. And what is important here is this is the procedural law, right? So procedural law basically means the entire procedure as to how do you file an FIR, how do you, what do you do? Do you file an FIR? Do you go to the court? Do you file a complaint with the magistrate? All that is covered under your CRPC, right? So CRPC, very, very essential because it tells you right from the very beginning कि आपने कैसे आपने केस शुरू होगा, कैसे आप केस फाइल करोगे, to how the police will conduct investigation. So right from filing of a case to the investigation by the police to how the case would go on in the court कि भाई पहले charge sheet file होगी, hearing of charge होगा, how will the entire criminal trial take place. All of this is given under your CRPC, right? So basically it provides you the procedure for the case to continue, right? Now, main reasons, I think, all of you are aware कि भाई colonialism के jungle से निकल के we want to become free, and that is why we've made these huge changes so far as the criminal justice system is concerned. And here also, if you look at the name was Code of Criminal Procedure. So it was basically just कि crime के लिए procedure क्या है. On the other hand, if you look at the way the law is framed now, the name now is Bharatiya Nagarik Suraksha Sanhita. So instead of the emphasis being on crime, the emphasis is given on protection. राइट, तो मतलब पूरा के पूरे ये जो तीनों लॉज के नाम है, इन्होंने यही बोल के चेंज करा है कि भाई हम सिर्फ क्राइम और पेनल्टी बेस्ड हमारा लीगल सिस्टम नहीं है. आवर लीगल सिस्टम इज मोर ऑन द लाइन ऑफ गिविंग जस्टिस, राइट, मोर ऑन द लाइन ऑफ गिविंग प्रोटेक्शन, right? So that is why the procedural code is now called Bharatiya Nagarik Suraksha Bill, right? So it's talking about protection of the people of the country, right? Now, so in today's session, what we will do is we'll have a quick discussion on some of the most important aspects of the new bill. So what are the, because there are a lot of changes which have been made to the bill. There are about, close to 100 and over 100 sections which have been changed. Of course, the basic procedure of how the cases will go on is still the same, right? Though there has been change in the chapters, in the numbering and all that is there, but there have been, certain substantial changes. So there have been certain additions. So certain sections have been added to the procedure code. Then there have been certain sections which have been repealed also, right? So we will discuss the important changes which have been made, and we'll follow that up with one question on your Bharatiya Nagarik Suraksha Sanhita bill, right? So we will do a passage and we will do 5 questions followed by that. Take. So let's begin now. Now, when you look at the Bharatiya Nagarik Suraksha bill, now these are some of the basic new things which are coming up. Now, the first very important thing which is being brought about by this law is that they're saying the greater use of technology. So when it comes down to trials, appeals, proceedings, now all of this, they have said that not only will it happen in a form which is the actual live form, but all of them can also happen in an electric mode. So which means that if you are looking at giving evidence, or if you're looking at filing an FIR, you need not always have to go to the police station, right? So everything is, the digitalization of the system is what is being envisaged under this particular law. Like when you look at the courts, the courts have already got a lot of digitalization. Like if you want to go to, let's say there's a matter listed in the Supreme Court or in the High Court or majority of your bigger district and sessions courts, there also, whether, okay, let's say your matter is listed for tomorrow, for the 17th of September. Then, for the 17th of September, on which number is my case listed? That is something I can know if I go to the website of that particular court, right? So digitalization, so far as the judiciary is concerned, has already happened, to quite some extent. So if you want to get some orders or get some, you want to know the status of your case, all that you get to know. If you type the case number, you type the name of the lawyer, then you get a list there, right? So similarly, they want to do a similar system so far as the police investigations are also concerned, right? So that is the idea. Of course, there are a lot of criticism of this also, that, okay, you want to do all this, but do you think the police are trained enough? Do you think they have the infrastructure to actually carry out these changes which have been envisaged? Those are some of the, the criticism which is being heard on this. But of course, there are always pros and cons. If there is going to be a change, that change will happen over a period of time, right? So the what the law is actually trying to do is a decent thing, right? It's a good thing. That's something which has to happen eventually. So if it's happening now, it's really, really good for our system, right? So that is one. Then it says statement can be recorded through video conferencing, exactly what I was telling you. Summons, warrants, documents, police reports, all this can also go in the electronic form, right? So earlier it used to be, if you want to call somebody, a summon is sent, is to be sent by post. But now they have said you can even send an email, it could be sent over the phone, right? So faster means of communication, bringing in electronic means of communication. Basically, it's talking about digitalization of the entire criminal procedure, right? So right from the stage of investigation to your trials, everywhere there is digitalization which is being introduced by the this particular act. Prior to this, CRPC did not really have this. There have been certain judgments wherein courts have allowed, Supreme Court has allowed that, okay, fine, you can do it, but specifically the law did not have this, right? So this is something which is use of technology is something which has been brought in by the new bill. Okay. Next is on the same lines is the bill adds electronic communication. And electronic communication, they are talking about electronic communication devices, right? So here they are basically, very specifically, they have referred to mobile phones, they've referred to laptops, that all these things are also going to be included. And it says on the direction of the court or the police officer, a person is supposed to produce any document or device, right? So here very specifically, they said that if for the investigation purposes, there is any evidence or digital evidence, then for those investigation purposes, the police has the authority to actually ask you to give your electronic device as evidence for investigation purposes, right? So this is something which has specifically been added under the new bill. Then there is this thing on use of handcuffs. Now, a use of handcuff is something which is permitted to the police officer if in case he's a repeat offender or a person who has escaped from custody or has committed an organized crime, etc. Right? Now, this was a clarity which has been brought about because, earlier there was a time when under Article 21, use of handcuffs is something which had been banned. That is why, frankly, if you ever go to a court, like when I was practicing in Delhi in the Tiswari courts, it used to happen, you would see a policeman and a person, another guy, and they're holding hands. It's like as though they're in some public garden or something, and then you realize, no, they're not allowed to handcuff the accused. तो जो पुलिस वाले होते हैं, कांस्टेबल साहब, वो हाथ में हाथ रख के अपने क्या बोलते हैं accused के साथ, they are walking around because you can't let the accused free, otherwise he's going to run away, but you can't even handcuff him, right? So therefore, that's a sight which generally I'm reminded of whenever I come across handcuffs. तो ये चीज, but इस particular जो भी act bill आया है, bill में they have specifically said that otherwise handcuffs not allowed, but if it is a person who's a repeat offender, custody, organized crime, terrorist act, and all these kind of specific cases, then you can use handcuffs, right? So basically you are giving a clarity on something, because end of the day, what happens is you might have a judgment on something, but if the law itself provides for it and provides for the exceptions, then it's much easier for the people on ground to carry out those things, so therefore it's a good thing that the clarity has been brought. Now, similar clarity has been brought on mercy petitions. Now, another very important thing which this bill is doing is it is providing you timelines. So timelines have been provided under the new bill, and these timelines are not only for mercy petition, these timelines are for, if you want to, in how many days an FIR is supposed to be filed, in how many days the charge sheet has to be filed. So all those things, in how many days investigation has to be there. So those timelines have been specifically provided under the bill. Those timelines were missing when you look at the CRPC at present. So strict timelines have been given, which is another important thing because, I'm sure all of you are aware, our legal system is, bolte hain ki bhai, justice to milega, but it takes so much of time for that justice that it's almost like justice delayed is justice denied, right? So what's the point of getting a justice if it's taking too long to get there, right? So therefore, timelines have been provided under the new bill. Ab yahan pe mercy petition ke liye kya bol rahe hain? They've said that if in case of a death sentence, you want to file a mercy petition, then it has to be within 30 days, right? So it says after being, so you have to give the mercy petition the timeline which has been provided. And if it is rejected, so it says relative can submit a mercy petitions within 30 days to the governor. So whenever the judgment as order is out, within 30 days of that, you have to submit it. And if it gets rejected, within 60 days, you have to file the mercy petition with the president, right? So there are specific timelines which have been given, and very specifically it has been said that no appeal shall lie from the order of the president, right? So once the order has been made by the president, then no appeal is going to lie from there if your mercy petition gets rejected. So otherwise, what used to happen was people would, file a mercy petition, and then that mercy petition, jab tak uska aayega, then after 6 months, after 1 year, again they'll think that okay, now I'll file to the president. So now they have provided timelines ki bhai itne din mein hi aapko apna mercy petition file karna hai, right? Mercy petition kahan pe aata hai? Mercy petition is something which is the pardoning power of the president given under the constitution, right? So pardoning power of the governor and the president given under the constitution, wahan se ye mercy petition ka concept aaya hai. Okay. Now let's move on to the next one, that is sanction to prosecute. Now, when it comes down to a public servant, usually you cannot file a case against a public servant directly. There has to be a sanction which you have to take from the government, right? Now, here very specifically they have said the decision to grant or reject a sanction has to be made within 120 days. Earlier there used to be a lot of lag that by public servant here, so you have to take sanction, and the government would not give, would neither reject it nor accept it, right? And there was no timeline. So here there has been a timeline which has been given that 120 days you have to give the, either reject the sanction or give the sanction. Okay? And it says if the government fails, then the default is going to be that the sanction has been accorded. That means sanction has been accorded, matlab ab case jo hai is public servant ke against chalega. Always remember, ये sanction कई बार passage based questions में आता है, sanction वाला concept. Sanction does not mean that the public servant is guilty. Sanction means that now a trial against that public servant can take place. Okay, because otherwise, अगर आप public servant हो, directly आपके ऊपर case नहीं चल सकता under criminal law, right? So generally, when you're talking about police, when you're talking about the army, there you need a sanction from the authorities, right? And very specific, there is no sanction. This has been carved out. This exception has been carved out. No sanction for certain very serious offenses like sexual offenses, trafficking. So serious offenses, they've said that no sanction is really needed, right? So that is something which is, again, the idea here is to avoid delay. That's the basic idea behind this sanction also. Now, next is when you talk about arms. Now, this is something interesting. Now, this is something which has been removed from the new bill. Ab yahan pe kya hua tha? If you look at it, in under section 144 of the present CRPC, you are prohibited. It says the district magistrate has the power to prohibit carrying of arms in any procession, mass drill, mass training to preserve public peace, which means that if there is, let's say, a mass procession which is being carried out, and the district magistrate feels that there might be a scenario where there could be disturbance of public peace, ki kuch violence ho sakta hai, rioting ho sakti hai, kuch bhi is type ka ho sakta hai, then in that case the district magistrate had the power to pass an order that people are prohibited from carrying any kind of arms during such procession, right? So because otherwise, when you're talking of carrying of arms as we're talking carrying of guns, are you allowed to carry guns on your person? Yes, you can, right? But ये यहाँ पे जब आप arms allow करते हैं, आपको arms allow करते हैं अगर आपके पास license है, right? So if you have a license, then in that case, आपको यहाँ पे arms allowed होता है to carry them, right? But the district magistrate here, if he feels there is a need, then in that case, ये जो है prohibition यहाँ पे लग सकता था. But now what has happened? This entire provision does not find a mention. This entire provision has vanished from the CRPC. That means अब जो है district magistrate के पास power नहीं होगा to prohibit you from carrying arms, right? That's something which is new. Then there is also this concept of samples. Now, usually, when you are talking about taking a signature sample, handwriting sample, voice sample, fingerprint ka sample, so CRPC protection provide karta tha that only if you are arrested, then you could be asked to give this sample. ठीक है, अगर आपको अरेस्ट नहीं करा है तो आपसे पुलिस सैंपल नहीं ले सकती है, चाहे आपके सिग्नेचर का सैंपल हो, फिंगरप्रिंट का सैंपल हो, वॉइस का सैंपल हो. This was not allowed under the CRPC, but The new bill says that नहीं, भाई चाहे आप arrested हो, चाहे आप arrested नहीं हो, you will have to give your sample, right? So this is again something which has seen some backlash कि भाई ये हमारी right to privacy को affect कर रहा है. Why are you taking samples when we are not even the accused if we're not being arrested, right? So but the bill here is talking about it कि बिना arrest करे भी आपसे ये samples लिए जा सकते हैं, ठीक? Next is when you're talking about detention. So there are these provisions for the police to detain or remove any person resisting, refusing, ignoring, disregarding directions given as a part of a preventive action, right? So here, even though आपने कोई crime नहीं commit करा है, because you're talking about a preventive action, right? So even though you might not have committed a crime, but still, if the police is saying कि भाई prevention के लिए आपको हमने detention में रखना है, then in that case, if you are resisting, refusing, then there are certain provisions, penalties for that also, which have been brought about in this act. Another thing, which of course is controversial. Next is trial in absentia. Trial in absentia basically means that the police has not been able to arrest you, but still आपका trial चल रहा है. Normally, if you're being tried, then you have to be before the court, right? But here, this trial in absentia concept has been brought. This basically is when you're talking about a person has been declared as a proclaimed offender. Proclaimed offender वो होता है जो जिसको हम हिंदी में कई बार बोलते हैं ना, wanted criminal है या भगौड़ा हो गया है, somebody who's been evading arrest, police has been trying to look for them but वो नहीं पकड़ में आ रहा है. Then in that case, what should the police do? क्या पुलिस वेट करती रहेगी कि हाँ भाई जब वो पकड़ में आएगा तब उसका केस हम कर लड़ेंगे? Trial in absentia, which has been introduced in this particular bill, they are saying that in case of offenses, like in case of proclaimed offenders, you can try them even if they are not been traced and captured. ठीक है, तो आपने हमने उनको arrest नहीं करा है, वो पुलिस custody में नहीं है, then also a trial can be carried out so far as they are concerned, right? So that is something which is again new under the act. Then there's this very nice concept of summary trial, right? So this is basically for petty offenses. Otherwise what happens is like the similar detailed trial is there for petty offenses also. So they are specifically talking about summary trial, and just to ensure that again justice is given in a faster manner. Okay, and also there is this concept of zero FIR, which can be lodged in any police station and which has to be transferred within 15 days. So zero FIR is basically an FIR which you can file in any police station. Usually क्या होता है कि अगर आप FIR फाइल कर रहे हो तो आप वहीं FIR फाइल करोगे जहाँ पे जिस particular थाने का, पुलिस स्टेशन का jurisdiction है. तो ऐसा नहीं है कि कन्याकुमारी में जाके आपने फाइल कर दिया for something, an accident which happened in let's say in Delhi, right? So that is generally not there. But zero FIR concept होता है कि आप nearest police station में जहाँ पे भी आप हो वहाँ पे आप lodge कर सकते हो, and your FIR will not be rejected just on the basis of the fact that आपका jurisdiction नहीं था, right? So zero FIR, and then that FIR, the bill says, will be transferred within 15 days to the police station which has jurisdiction, right? So ये जहाँ jurisdiction है वहाँ पे ये transfer हो जाएगा within 15 days. So again, something to help make the system a little more easier for the general public, right? That is the basic idea behind this provision, right? तो ये थे हमारे कुछ important provisions so far as the भारतीय नागरिक सुरक्षा संहिता बिल. भाई इतने टंग ट्विस्टर नाम रखे हैं ना, it'll take some time for general public to actually get used to कि ये टंग ट्विस्टर नाम होगा. In fact, that's one of the reasons the lawyers had been protesting कि भाई इतने difficult नाम रख दिए हैं. It's so difficult to even get around using them, right? But of course, but that's a very petty reason. वो चीजें तो हम याद कर ही सकते हैं थोड़ी देर में, right? But anyway, so now let's move on. Now, if anybody has any doubt in what we have done, किसी को कुछ पूछना है तो आप पूछ सकते हो अभी, ठीक है? And otherwise, we are moving on to our question now. ठीक है? So I have a passage right here. I want everybody to read the passage. Okay, go through the passage thoroughly, and then I have a set of questions for you on the basis of this passage. ठीक है? So I will give you guys about let's say some 3 to 4 minutes to read the passage, and then we will continue with the questions, right? So those of you who are here attending the session right now can try and answer, and those of you who are looking at later also as a recording also, try to be true and try to answer the questions first, and then go on to the answers when I actually tell you. Okay, so please read kariye, and then we will begin. Okay, I'll give you guys 5 minutes. I'll keep mum for a bit. Okay. Oh, I'm sorry. I'll go back to the, I've gone back to the passage. I think there was some change to the page. Okay, I think guys would have read the passage by now. So I will give you guys one last minute, and uske baad hum questions pe chalte hain. ठीक है? One last minute, please. Okay, so let's begin. I'm moving on to the question slide. Okay, this is your first question. Please, everybody read it, and then you can quickly type the answers in the chat box. So even, those of you who look at the video later as a recording, I would recommend that, type the answer in the chat box. It's fun to remember. It's a good way to remember your answers also. So, feels more real when you do it like that. Wow. चलो अब यहाँ पे क्या हो रहा है? Here, if you look at it, what are they saying? It says that Deepak's head, so it says hit Deepak's head with a heavy metal object, killing him instantly. Right. So यहाँ पे हमारा किस चीज का केस बना है? For causing death. So either it is going to be culpable homicide or it is going to be murder, right? But for sure, this is going to be one of the offenses. अब here, if you look at it, the person has run away, and very clearly it says police looked for him everywhere but failed to trace him. There are several summons and warrants which have been issued to all his known addresses, but they've not been able to trace him. They've not been able to find him. Right. So in effect, what has he become now? Can we put him in the category of being a proclaimed offender? Yes, if you look at the passage of the last paragraph, so that is exactly what it is talking about. I'll just take you back to the passage once. If you go back to the passage, very clearly it says that who is a proclaimed offender? If it's a person accused with an offense punishable with imprisonment for at least 10 years or death, and fails to appear at specified time and place as specified by the court. So here, if you look at it, दोनों की दोनों चीजें यहाँ पे fulfill हो रही हैं, right? So here, he's been missing, 10 years हो चुके हैं. So it's been like he's been missing, he's been asked by the court to come, but वो गायब है, right? And but एक चीज है, some of you might think that ma'am, यहाँ पे लिखा है the accused of the offense he has to be accused of an offense punishable with imprisonment of at least 10 years or death. अब कहीं भी पैसेज में ये तो लिखा नहीं है कि भाई मर्डर के लिए या कल्पेबल होमिसाइड के या causing death के लिए, because we won't even use those words. For causing death, that a person will be punished for 10 years or more. Right now, this is in CLAT, always remember this little bit of kind of a reasonable man वाला जो लीगल नॉलेज है वो थोड़ा बहुत यूज होता है. That's the specific reason I made this question. No, I did not want to put in that info here कि भाई मर्डर कल्पेबल होमिसाइड होगा और उसकी पनिशमेंट जो है वो इतनी एक्स हो सकती है, right? X amount of punishment would be given. But even if that is not given, still you will presume itna thoda sa, bahut thoda sa hai, because here it is not really a presumption, it is more like thinking like a reasonable person, right? So isliye this is something which you would take into consideration, right? Now if you're taking that into consideration, he is running away or offense 10 saal se zyada ki punishment wala hai, so obviously answer is going to be he can be declared as a proclaimed offender. That is one. Second, B option बोल रहा है the court after conducting a trial can pronounce the judgment in the case holding him guilty. Can this be done as per the passage? Yes, I mean there can be a judgment, and अगर judgment है तो judgment can be either ways to hold him guilty or not guilty, right? So if the court finds it after conducting a proper trial, this can also be done. So you clearly know your answer has to be option D, right? C nahi hoga because C says court will have to first ensure his attendance. Now this is exactly what is the difference that the new bill has brought about, right? So your correct answer here is going to be option D. Okay, so let's move on to the next question. हाँ जी, short and sweet question है, फटाफट पढ़ के आंसर दीजिए. Please give me the answers, everybody. थोड़ा सा लैग होता है YouTube में from where I am to where you are, so I'll give you a little bit of additional time, and I want you guys to answer the question. Now here it is the same as the previous question, but what are we saying? We are saying that if unlike in the previous question जहां पे हमने बोला था बिल के accordingly क्या होगा, यहाँ पे present legal system के हिसाब से what is going to be your answer. Now if you look at the way the passage is framed, you would realize that for sure ye second wala part, that the court after conducting the trial can pronounce him guilty, this is something which has been introduced right now, right? Very clearly the language of the passage is telling you this is something which cannot be your answer. Now here, if between A and C, so a B out ho gaya and your D is also out. Okay, so how many of you here So those of you here, can you tell me what is going to be the answer? A होगा या C होगा? As per the passage, as per what is given in the passage, the information provided in the passage, what would be your correct answer? कौन सा होगा इसमें, A और C के बीच में? Between the two of them, your better answer is going to be option A. Right now, C says court will have to first ensure his attendance, only then the trial can be conducted. This information we cannot get from the passage. Passage में कहीं भी clearly ये लिखा नहीं है कि आपको पहले attendance लानी पड़ेगी, only then the trial can take place. It is saying that in absentia हो सकता है, but it is not saying कि पहले CRPC में नहीं होता था, right? That's not something, and attendance is something which is essential. So ये चीज जो है, this is not something which is being brought out. But what is a proclaimed offender? That definition has been given, and the passage is not saying कि जो proclaimed offender की definition है, ये जो है इस bill के अंदर है. Right, this proclaimed offender ki definition is already existing definition, right? So therefore, your answer here is going to be just option A, that Rahul can be declared as a proclaimed offender. Uske baad trial ho sakta hai ya nahi ho sakta hai, that is something which we are not sure about from the passage, right? So aapka information ye passage mein nahi diya hai. And this is like too much of something to, really to be reasonable enough to come up with also, right? So that is not expected. So correct answer is option A. Let's move further. अब next भी इन्हीं set of facts पे हम चल रहे हैं. So I'll give you guys 2 minutes to read, and then we will start. Okay, अब यहाँ क्या हुआ है? Sorry. So in this question now what has happened is that they are saying that the police reached the crime scene, and what do they want? They want that sample of fingerprints for investigation purposes, right? So they want sample of fingerprints for everybody. Rahul's servants, friends, family members, सबके उनको fingerprints चाहिए. Now, if you look at the provision in the new bill regarding this, there is a very specific thing which is provided in your passage कि जो bill में और जो पहले था वो फर्क क्या है, right? पहले अगर आपको fingerprints का sample चाहिए, any other sample if you want, then you actually had to arrest the person. आपने अगर arrest करा है किसी को, only then you can do it, right? But here things have changed, and as per the bill, even if you're not arrested, still the samples can be collected, right? So will these people, so if what the question is asking is, what advice would you give them keeping the provisions of the bill in mind? So the advice has to be कि boss आपको ये sample जो है देना पड़ेगा, right? आप avoid नहीं कर सकते देना. So which is the option? Now A says giving fingerprints is violative of their fundamental rights against self-incrimination. भाई ये completely outside the passage है. ऐसा option में तो आपने ज़्यादा दिमाग लगाना ही नहीं है, because this is not something which is given in the passage. बहुत ही technical knowledge है ये, not provided in the passage, outside scope, out. B says they should help the police in investigation and are duty bound under law to provide fingerprint samples. अब इसमें जो first half है ना, वो ऐसा लगता है कि ये क्या moral science का lecture है. This should not be the correct option. But in the second half is not so incorrect. And it says you're duty bound under law, and bill जो है आपको duty bound करता है. So we can keep this option open. Such an option you keep it open. It's not a very beautifully drafted option. तो आपका सीधे जाके ये correct answer होगा is something which is difficult to assess, right? C में आ गए. अब C बोल रहा है the people who have been arrested are only required to give fingerprint samples. अब this is the situation under the present law. अगर यहाँ पे question में ये bill की जगह पूछा होता कि under the CRPC या present law के under क्या status है, then my answer would have been option C. But right now, of course, मेरा answer C नहीं हो सकता, right? Next is, it says the police will have to establish a prima facie case before seeking fingerprint samples. Now, this is something which has not been mentioned anywhere in the passage. कि भाई आपको पहले अपना केस थोड़ा सा establish करना पड़ेगा, एक basic case, और उसी के बाद आप fingerprint sample ले सकते हो. Again, not given anywhere in the passage, completely outside the scope of the passage. अब क्या देखते हैं हम? That A, C and D have been eliminated. वो हो गए हमारे negate. So the only option left with you is option B, which to begin with was a little iffy, क्योंकि वो बहुत अच्छे से, the first half was a little too vague, right? कि help करनी है पुलिस को, moral science type था, but end of the day you realize कि बाकी सारे options जो है वो negate हो गए. So then you go to the best possible option, right? So answer B is your correct option here. Chalo, let's move forward to the next question then. अब जो हमारा next question है वो बात कर रहा है CCTV camera, right? I'll give you guys a minute to solve it and then we will discuss. Just a minute to all of you. Then that 1 minute I'll have a sip of water. You. So, अब यहाँ देखते हैं. अब इस question में क्या हुआ है? Now, if you look at this question, it says in the above case, the police wants to use the CCTV footage, right? तो अब ये जो CCTV footage है, neighbor के घर की आपको use करनी है, right? So, is the neighbor supposed to give this CCTV footage? Is it something which is provided in the passage or no? Now, when I look at the option, A says CCTV camera is an electronic communication device, hence it can be used as evidence, right? So, इसमें question क्या arise होता है कि क्या ये CCTV camera जो है, वो जो हमारे passage में electronic communication device का definition दिया है, क्या ये उसमें fit हो रहा है? So let's just quickly scoot back. Let's go back to the passage. एक बार देखते हैं कि passage के अंदर क्या ये possibility है या नहीं है. Now, if you look at the passage में बात करी है ये paragraph में, when you're looking at electronic communication devices. Now, it says that may be held in electronic mode. It says also provides for production. Now, this is what is relevant of electronic communication devices likely to contain digital evidence for investigation, right? And then it says it includes communication through devices such as mobile, computers, and telephones. Right now, the question which arises here is, क्या एक CCTV camera, is it a communication device like a mobile phone, like a computer or a telephone? You know, I understand that generally, if you look at, if you are just looking at electronic and communication thing of it, then you feel that CCTV camera to ho sakta hai, because what does a CCTV camera do? It captures the image and which is then transmitted. So it is transmitted either to a mobile phone, it could be transmitted to a laptop, it could be transmitted to some sort of another device, right? So it is kind of communicating what, electronically communicating the picture which has been captured by the device. But when we look at very specifically की definition क्या दी है यहाँ पे electronic communication device की, it says it includes communication devices, it includes communication through devices such as, so important चीज क्या होगा कि यहाँ पे ये inclusive definition दिया है, यहाँ पे ये एक कोई exclusive definition नहीं दिया है, right? So to come to think of it कि सिर्फ mobile, computer और telephone ही electronic communication device होंगे, that is going to be incorrect. So if you look at a CCTV camera is also doing exactly that. It is communicating, you know, through, you are capturing an image and you are communicating it, you are sending it to another device. So अगर आप यहाँ पे आप send भी कर रहे हो, then that also becomes an electronic communication device, right? So let's go back to the passage and see which is going to be your correct answer. So, a minute, I will just take you back to the question that we were on here. So let's see which is going to be your correct answer in that case. A says CCTV camera is an electronic communication device, hence it can be used as evidence. Looks like a solid answer. We keep A open. B says the court can order the production of CCTV footage as it is an electronic communication device likely to contain digital evidence for investigation. Right now, this is something which is also correct. And when you compare A and B, you know, obviously your answer is going to be option B. You know, very specifically, this is giving you the reasons exactly in terms of your passage, right? So B is going to be a better answer. C, of course, nahi hoga. C is saying that the neighbor's fundamental right, bhaiya fundamental right ki to kahin baat hi nahi ho rahi hai. So that cannot be your answer. And none of the above will also not be there. Your correct answer is option B. Okay, so let's quickly move on to the last question of the evening. Okay. Now, I'll give you guys a minute. Now, in this question, what do you see? Here, very clearly, now the same case is going on for the arrest of Rahul, and we are saying the trial has taken 7 years, right? So 7 years he has spent as an under trial. But if you look at the passage, what does it say? Passage says that if the new remedy, which if you look at the bill, it said that until and unless it is for something which is punishable with imprisonment for life or for death penalty, then in that case, if you're an under trial, if you spend half of your time, then you can be released. But here, clearly, Rahul has been arrested for something which is punishable with life imprisonment, right? So therefore, he is not going to get the benefit of the new provision given under the bill, right? So therefore, if you look at the answer has to be he will not get any relief, right? Because of the kind of offense he has committed, right? So not get any relief. Up between C, A and D, कौन सा option better है? A बोल रहा है because it is his fault that the trial is taking too long, and D says he cannot be released. So obviously your answer will have to be option D and not A, because A is saying his fault. Now that's not an answer. A, it is incorrect, and B, it's not even based on your passage. So उससे अच्छा तो option D है जहाँ कोई reasoning ही नहीं दिया है. Instead of a wrong reason, it's better to have a no reason. ठीक है? चलो. So this is where we come to an end of today's session. I'm hoping that, there is some clarity in your minds vis-a-vis this new bill that has come into play. बहुत ही important है आपके CLAT के perspective से, these kind criminal law any which ways is something which you know is an important part of your CLAT syllabus for the legal reasoning section. And उसमें इतने important changes ये हुए हैं. So there is a big likelihood that you might just come across them in your exam, right? So do read about it and do keep in touch with us. These are our social media handles. I would request all of you, if you're in doubt, you need any help, you can always come and ask for help to us, right? I'm Neha and I take the legal reasoning section of the CLAT paper for CLAT Possible. So please do get in touch just in case you have any doubts, queries. You can always use the comment section here also and get in touch with us. Okay, chalo. Take care, everybody. Bye-bye and happy studying.